I'm Bay McFarland, and I'm the founder of Mary's Advocates, a nonprofit educational organization dedicated to upholding marriage as the Catholic Church understands marriage. And in light of Pope Francis's commission on streamlining the annulment process, recent news that came out Tuesday, September 8th, I've put together a little video collage where I'm going to throw in some comments in between. Some of the excerpts are from Cardinal Raymond Burke and his presentation that he made on that same day, September 8th, at Franciscan University, where I was present, and I did ask him a question at the end. And some of the clips are from him earlier. Some of the clips are from the theology professor at Franciscan U that's raising concerns about divorce. I raise concerns about no-fault divorce. And then some of the clips I've thrown in here are from the judicial vicar of the Archdiocese of Columbus and what he says on the internet about annulments. Now, why should anybody care about any of this? If the church is trying to be a unified church and we're trying to follow what Jesus says about marriage, it's important that we get all this stuff straight. Either everyone who's unhappy can abandon their marriage or leave their marriage and get an annulment concluding that their marriage never occurred, or not. And if not, what happens to us? So here we go. The first clip is from Cardinal Raymond Burke, and he's addressing the claim that a lot of the marriages are simply invalid because we live in a secular culture. And to put what he says in my own words, he says that doesn't make any sense because by nature, the nature that God gave man, we know what marriage is. We know what it's essentially about, permanence and children and so on, and we want it by our nature.
In the current discussion regarding holy matrimony, and in particular its intrinsic indissolubility, it is frequently asserted that a great percentage of marriages are surely null. The reason given is the highly secularized culture in which we live. Secularization denies the natural law which teaches us that marriage is a faithful, enduring, and procreative union, that it is a faithful and enduring union between one man and one woman. The argument is that many parties who exchange marriage consent today do not understand what they are consenting and therefore exclude from their consent one or more of the essential goods of marriage: unity, indissolubility, and procreativity. Given the pervasive practice of no-fault divorce in particular, it is asserted that many parties affected by what is called the divorcist mentality exclude by a positive act of the will the indissolubility or permanence of the marriage bond. Whereas in the Church's discipline, marriage always enjoys the favor of the law, that is, that consent is presumed to be valid unless the contrary is proven with moral certitude, some today would hold that marriage consent in as many as 50% of cases can be presumed to be null or invalid. The first argument, in fact, against the presumption of nullity of marriage consent is human nature itself, is the law which God has written on every human heart. No one denies that the culture has a negative effect on the giving of true matrimonial consent and on the living of the consent in practice, but that does not mean that young people today do not understand what marriage truly is and desire it in itself. To assert that they do not know the natural moral law is in fact to deny human nature, which teaches the truth about life, about marriage as the cradle of human life, and about our relationship with God, which expresses itself in worship of Him.
So Cardinal Burke said most young people are capable of knowing and understanding what marriage is, even though there is a lot of divorce going on around us just because of our human nature. This next clip, he explains why the marriage rite itself, the actual words that we use in the marriage rite, are another reason to argue that marriages are valid.
A second strong argument in the case of Catholics and non-Catholics who celebrate their marriages according to the rite of marriage in the Roman ritual is the reflection of the truth about marriage in sacred worship, and in particular in the rite of marriage. According to the ancient wisdom expressed by Prosper of Aquitaine, the law of praying establishes the law of believing. In other words, the truth of the faith finds its highest and most perfect expression in the sacred liturgy. It is difficult then to comprehend how one can celebrate liturgically the sacrament of holy matrimony without understanding and intending the truth which finds its highest and most perfect expression in the liturgical rite. It is particularly important to consider the truth about marriage as it is expressed in the sacred liturgy, and in particular in the rite of marriage of the Roman ritual. Apart from the introduction, which is called the prenotanda of the rite of marriage, which underlines clearly and thoroughly the Church's constant teaching regarding marriage, the central elements of the rite all manifest the great truth of marriage. They are the liturgy of the Word with the required homily of the priest or deacon, the questioning of the parties regarding their intention, and the actual exchange of consent before God and his minister, the priest or deacon, the nuptial blessing, and the participation in the Eucharistic sacrifice and the reception of its incomparable fruit, the body, blood, soul, and divinity of Christ. The sacred liturgy is the greatest teacher of the truth about marriage, and therefore a safeguard against an invalid celebration of the sacrament of holy matrimony through the exclusion of one of the essential goods of marriage.
To prepare you for listening to the next excerpt, I want to read you a quote from a judge at the Tribunal of the Roman Rota, which is one of the appeals courts for the whole world. The quote was given by Monsignor Kenneth Bocafola to Father James Ponce. Father Ponce was working on his dissertation, interviewing the Roman Rota judge. Father Ponce was a student at the Pontifical University of Holy Cross in Rome. He graduated in 2012 summa cum laude. The Roman Rota judge said that there are three primary reasons why cases arriving at the Rota are overturned. A, the facts are not well grounded and do not support the chapter of nullity. B, there are some flaws in the interpretation of doctrine and jurisprudence. For instance, they use the more generic term for immaturity rather than psychological incapacity, and there are violations in procedural norms.
Most of the cases we process on what's called 1095-2, which is the canon that has to do with a grave lack of due discretion of judgment. Now, what that means practically is this.
Let me stop you for a second. That's Canon 1095-2.
1095.2. It's the second paragraph, Canon 1095.
Okay. But most of it is in 1095-2, which is what you said is, again, is called a lack of
due discretion, which means you have to know what marriage is. You have to evaluate the appropriateness of being married to this particular person. And 3, you have to be free. You have to freely do it. There are a couple of ways that we can investigate defective consent, but most of our marriage cases have to do with 1095-2. Do they know what they're getting into? Have they reflected, weighed, balanced, chosen, talked to each other about this? You'd be surprised how many people that are married haven't talked about 10 essential areas: religion, finances, in-laws. You know, there's 10 of. You'd be surprised how many people don't talk about a whole lot of things before marriage. And the third is being able to be free.
And the one that I often encounter the most, I don't know if this is true for someone that works in the tribunals, is simply a lack of maturity. Yes. And with that, so you know, maybe they're 25 chronologically, but they might have the maturity of a 15-year-old. So how does that mature? Because that's what I've encountered a lot of times is a maturity.
That's the grave of maturity. That's it. And I see that a lot in couples, and we see it. Plus, a person can be very when it comes to academics, when it comes to business, when it comes to those kinds of things. But to be absolutely adrift when it comes to relationships with people, and particularly intimate relationships. Sometimes psychologists and sociologists tell us that because of our American culture, which has a tendency to be somewhat infantilizing as a person is growing up, that people really have problems achieving maturity much before their late 20s or 30s even, or early 30s. And some people can be immature in the way they conduct their close relationships like marriage. And we see this all the time, that they may be chronologically mature, they may have a great job, they may have a wonderful education, but they just don't have the proper maturity when it comes to selecting a partner to go through life with.
Or perhaps that day they didn't have the maturity. Sure. I see that happens a lot in terms of those kind of things. Maybe real briefly we could let me stop there for just a second. Two things in regards to this. One is that again, I like have people in my office liken it to a contract. You can't have a 16-year-old sign a contract in civil law because they're not of legal age. And I say, well, sometimes people are 16 in their heads even when they're 25 in their bodies. And so the church sort of sees the same thing, that they might have been, so to speak, underage in a maturity way, not a chronological way, and then so they weren't really allowed to do that sort of thing.
And we try to investigate all those things.
Shown here is a photocopy of the Canon Law Society of America from 1985 commentary on Canon 1095-2, saying the same thing the judicial vicar said, that someone could be mature in other areas of their life, but just not mature enough for relationship. I'm showing you a book that was just published this summer by Pablo Bianchi. It was originally published in Italian in 1998 and translated into English this summer. When is the Marriage Null? Guide to the Grounds of Matrimonial Nullity for Pastors, Counselors, and the Lay Faithful. The foreword to the original edition was written by Dean of Professor Emeritus, Faculty of Canon Law, Pontifical Gregorian University, Rome, March 1998. That was Urbano Navarrete. And in the foreword it says, the author earned a doctorate in 1988 with a dissertation directed by Professor Versaldi entitled Inability to Assume the Essential Obligations of Marriage, Analysis of the Jurisprudence of the Roman Rota, particularly in the years 1970 to 1982. This weighty volume with 350 densely printed pages that includes one of the most complete bibliographies on the subject available to date. In the book we are presenting now, the author returns to this topic and devotes 2 chapters to Canon 1095, the first about numbers 1 and 2 of the canon under the general title Inability to Consent, the other about number 3 entitled Incapacity to Assume the Essential Obligations of Marriage. We do not hesitate to assert that the aforesaid chapters are without a doubt well-grounded, indeed probably among the best pieces published to date concerning a matter that is so complex and delicate. The 2 chapters in this book, published by Ignatius Press just this summer, don't sound anything like what the Judicial Vicar of Columbus is saying or what the Canon Law Society of America was saying in 1985.
Next, we have Dr. Donald Ashe, Professor of Moral Theology.
In Familiaris Consortio, Pope St. John Paul II describes bearing witness to the inestimable value of the indissolubility and fidelity of marriage as one of the most precious and urgent tasks of Christian in our time. While it primarily reconfirms the good news of the definite nature of conjugal love that has Christ as its foundation and strength, Catholic teaching on the indissolubility of marriage also includes the explicit recognition of the immorality of divorce itself, even apart from the compounding evil of civil remarriage after divorce. However, as recent discussions of the indissolubility of marriage surrounding the Synod have suggested, few seem to find exploring the evil of divorce in itself to be an important topic, much less an urgent task, with our focus instead being shifted to the cases of those who compound the evil of divorce with a civil remarriage and their situation regarding Eucharistic communion. I propose that we redouble our efforts to address divorce as a grave offense against the dignity of the human person by approaching the question through the spousal meaning of the body articulated in St. John Paul II's Theology of the Body. Viewing divorce from the perspective of the spousal meaning of the body makes the evil of divorce more clearly an affront to the intrinsic value of the person and shows it to be a type of consumerism in the marital sphere, which in turn likens divorce to the evil of euthanasia, insofar as divorce can become a way of ridding oneself of a person by a rationally justified affront to the dignity of that person.
I jumped right into the presentation by Professor Donald Ashe, the moral theologian from Franciscan University, because he makes a really good point about the indissolubility of marriage relative to divorce. And the news is giving us the impression that there's a lot of focus on the Bishop Synod about what to do with those who are in second unions after a Catholic marriage, and we're not hearing anything about what to do about those who are divorced, or more particularly about those who left their marriage or forced their family to go through a divorce. I'm holding in my hands a brochure that Mary's Advocates just put together, Separation and Divorce from a Catholic Perspective, and there is canon law about what's supposed to happen before a Catholic even files for divorce in the civil forum, and these canon laws are not being applied or adjudicated in the United States. And I question whether these canon laws on separation and divorce are being ignored because so many people in the United States assume that marriages are invalid when someone is terribly unhappy or they have a serious problem. I have found in my research that where half the United States population resides, the tribunals grant annulments to over 98% of the petitioners who apply. And I asked Cardinal Raymond Burke about that at the end of his presentation. But for now, let's jump back and see what Professor Ashe says about divorce.
In sum, then, we need to make recognizing the indissolubility of marriage and the evil of divorce a prominent feature of our Catholic faith and identity, something along the lines of the way in which we are pro-life and in the ways in which we speak out against the recognition of same-sex unions, precisely because the gospel requires us to defend the dignity of the human person and to foster hope among ourselves and the world around us.
Professor Ashe was very clear that divorce is immoral, and I want to contrast that to what the Columbus, Ohio judicial vicar has to say. He describes how divorces happen, kind of like thunderstorms happen, and he makes no recognition between the differences between a party who might have had a morally legitimate reason to separate versus a party who had no reason to separate and was simply abandoning their marriage or abandoning their marriage and committing adultery on top of it. Listen to what he says.
Whenever divorce happens, Josh, and I think that people have to understand this, that the church understands how painful it is and how difficult it is and how hard it is not just for the couple but also for the children, but for the families. And so the church wants to reach out in compassion and to help people through this, because most people think that if they get divorced that they aren't allowed to receive communion anymore, and that's not the case. The problem is divorce and then remarry without having been through this process of investigating and asking the church to render a judgment on the validity of that marriage that broke up.
And that's what I tell people as well. Is I tell them that divorce is really not the problem; it's the remarriage that is the problem.
That's precisely.
Yeah.
It appears that the judicial vicar of Columbus, Ohio, does not know about the canon law on separation relative to divorce. Particularly, no one who married in the Catholic rite of marriage is even allowed to apply for a divorce in the civil divorce courts until after first getting the permission from the bishop. Cardinal Burke has some explanation as to how things got so lax in the United States. I'm going to show you two clips. One is about 5 minutes from what he said last year at a presentation at Catholic University of America. The next clip is about 3 minutes, and it's what he said this past Tuesday on September 8th at Franciscan University of America.
The third and final consideration pertains to the necessity of a double conforming decision for the execution of a declaration of nullity of marriage, that is, a second decision on the merits of the case. There is a sense among some in the Church that a decision has already been taken to eliminate the obligation of a double conforming decision as one of the elements of the so-called burdensome juridicism in the current process of nullity of marriage. Many have asserted that if the process is done well in the first instance, there is no need of an obligatory review in second instance. First of all, I observe that if the process is done well in the first instance, the process to arrive at a double agreeing decision with a decree of ratification will not take too long. By done well, I mean that the case was well instructed and discussed, the acts are complete and well ordered, and the sentence demonstrates the objective basis for the decision, indicating in a clear but prudent manner by what path the judge or judges, on the basis of the law and the facts of the case, reached moral certitude that the nullity of marriage had been proven. What is more, good judges conscious of the fundamental importance of the marriage union for the life of the church and of society in general, and of the normal challenges in reaching a just decision in a cause of nullity of marriage, are grateful that their judgment will be examined by other judges in a second instance. From the practical point of view, the fact of the obligatory review in second instance is an incentive to do one's best. Without the second instance, there is a risk of carelessness in the treatment of causes. This was demonstrated by the period in which the so-called American procedural norms were in effect. From July 1971 to November 1983, the obligatory double conforming sentence was in reality eliminated in the United States of America by means of a faculty given to the Conference of Bishops to dispense from the same in, and I quote from the document granting these norms, those exceptional cases wherein the judgment of the defender of the bond in his ordinary appeal against an affirmative decision would clearly be superfluous, those exceptional cases. By all accounts, in practice, the only exceptional cases were those in which an appeal was not considered superfluous. Furthermore, I have never come across any indication that the Conference of Bishops ever denied a single request for dispensation out of the hundreds of thousands received. In the course of those 12 years, when the Apostolic Signature had occasion to review some of those same cases, it could not understand how the defender of the bond in his ordinary could have considered an appeal superfluous, much less how the Conference of Bishops could have granted the requested dispensation. In the common and popular perception, and not without reason, the process began to be called Catholic divorce. Even after this extraordinary situation was finally ended, when the 1983 Code of Canon Law took effect, the poor quality of many first instance sentences examined by the Signatura, together with the evident lack of any serious review on the part of some appellate tribunals, has demonstrated the grave damage done to the process of declaration of nullity of marriage by the effective omission of the second instance during those years. From the rich experience of the Apostolic Signature, which obviously is not limited to that of the United States, the necessity of the double conforming decision for an adequate process for the declaration of nullity of marriage is shown without any shadow of a doubt. By means of the study of the annual reports of the tribunals and the examination of definitive sentences of tribunals of first instance, the wisdom and the importance of the requirement of the double conforming sentence, which we owe to that brilliant canonist and Roman pontiff, Prospero Lambertini, Pope Benedict XIV, is more than ever evident.
The relationship between doctrine and discipline. In what regards the canonical process for the declaration of nullity of marriage, it is frequently said that changes in the process can be introduced without affecting in any manner the integrity of the doctrine on the indissolubility of marriage. But it is evident that an inadequate process for arriving at the truth regarding a marriage accused of nullity would bring with it a lack of due respect for the indissolubility of holy matrimony. In fact, in the United States of America, from 1971 to 1983, a very modified process with a diminution of the figure of the defender of the bond and the effective elimination of the double agreeing sentence was permitted by the Holy See. With time, and not without reason, The process for the declaration of nullity of marriage became popularly known as Catholic divorce. In other words, in the common perception, while the Church was declaring the indissolubility of marriage in its teaching, in its practice, it was permitting parties held to a marriage bond to marry another person without having first demonstrated the nullity of the earlier marriage bond. I served for many years at the Apostolic Signatura, first as defender of the bond from 1989 to 1995, and then as prefect from 2008 until November of last year. In a consistent manner, the experience of the Apostolic Signatura shows that when a matrimonial tribunal has well-prepared staff, the causes proceed without unjustified delays. At the same time, a process to reach a decision in so important and delicate a matter, the salvation of the souls involved, has of necessity its proper times for gathering the proofs, for examining them, and at the end, for giving a judgment with moral certitude. With sadness, many times I have seen that the diocesan bishop has not sufficiently taken care to prepare well the necessary personnel for his tribunal. In other words, it is not the process that has need of modifications, but the practice of some bishops who do not provide well-prepared and just workers for their tribunals. Here,
The same day that Cardinal Burke made these comments on September 8th, that morning in Rome, the Pope's Commission of 11, who had been working on streamlining the annulment process, had a press conference where they publicized the Motu Proprio, which is Pope Francis's changes to the canon law. And one of the things that was done was what Cardinal Burke was warning against. They got rid of the automatic appeal in cases where a first tribunal ruled that a marriage was invalid. And consequently, the tribunals will know that no one is watching them, if knowing that someone was watching them was any instigast to not give annulments when there really wasn't a basis for them. Also part of the annulment reforms, according to Ed Peters, is that the bishop now has the authority to make a decision about an annulment, and he can use helpers who are not canon lawyers, and the bishop doesn't have to be a canon lawyer. And Ed Peters raised concerns that this could cause issues when the people who don't understand the complexities of what is a legitimate ground for annulment versus what is not are the ones who are now entrusted to make these decisions. Ben Wynn, who is a canon lawyer from Florida, he wrote an article and he had said that one of the changes was that we no longer need to have witness testimony corroborated by somebody else. So if one witness, who I say happens to be the petitioner, says my marriage is invalid because I was immature, period, and if the bishop thinks that's a reason for invalidity, then the bishop doesn't need to have anyone corroborate whether or not the petitioner was really so immature at the time of his marriage. Back to Ed Peters, he also raised concerns that these changes were done by a committee of 11 who were primarily from one country, and Ed Peters used the word stunning. Kurt Martens, who's a professor at Catholic University of America in canon law, he was quoted in a story saying that this whole process is now like no-fault divorce from a Catholic perspective. Cardinal Burke, in his address on September 8th, had cautioned why he thought that an administrative process where the bishop was in charge of deciding about annulments was a bad idea, and I'll let you hear that next.
The proposal of an administrative process for the declaration of the nullity of marriage conducted by the diocesan bishop or his delegate is unreasonable. It requires the bishop or his delegate to reach a most grave decision without providing for him the necessary elements to reach the decision. The proposal, in fact, was first advanced by the late Monsignor Stephen Kelleher in his presentation at the International Convention organized by the Pontifical Commission for the Revision of the Code of Canon Law in May of 1968. The proposal, over the many years of discussions in the preparation of the 1983 Code of Canon Law, was never accepted.
Cardinal Burke said one of the problems a bishop would have is that he doesn't have any process that includes the necessary elements for ensuring the development of a just answer in cases where the bishop's doing an administrative process for nullity. Before the announcement was made for the streamlined process, Mary's advocates had been working on a suggestion that we did send to the Commission of 11, whereby we suggested that using modern technology, the necessary elements could be a lot easier and faster to get. With a document management system on the internet, all the steps could be on the internet, so the people participating could do it from home or they could do it from a parish office. The judges who are the canon law experts on certain subjects, like those who know Canon 1095 or those who know Canon 1101, subject matter experts could be judges, and the tribunals could help each other in this way. This link is the bilingual document that we did send to the Commission of 11. This next excerpt is Cardinal Raymond Burke answering a question from an attendee about how to minister practically to the people who are in these second marriages that are adultery. And after answering the question, Cardinal Burke also talked about how people approach him who remain faithful to marriage after separation and divorce. And Mary's Advocates has a support for those kind of people too in our book, The Gift of Self, and our group, Separated Faithful, which is in the link here.
Next question.
This is for Your Eminence, and I was wondering, what do you think some good practical ideas are to bring those who are in these so-called second marriages back into communion with the church? Because, of course, it's difficult to tell someone that they're living in a state of adultery and that they need to change the way they're living because, they've obviously formed a deep bond with this person, even if it is sinful. So how would you recommend that we best evangelize them and bring them back to the church? Thank you.
Well, if indeed one or both parties are bound by a valid marriage, then one has to help them to live as friends. The brother and sister relationship has always been proposed by the church for people who find themselves in these situations. And we have the grace to live in fidelity to that marriage to which we are bound, and that would mean in the situation of those who are living in an irregular union, a call to live a form of heroic chastity, but we're quite capable of that. That's not for the elite or only for certain people, and so we have to try to help those who are living in that situation to live a chaste life. I've been giving presentations over the past year especially on marriage and the family, and I've encountered so many after these presentations, so many individuals who have come up to me and told me how their spouse abandoned them at some point and how they find their joy even in the suffering which is involved with it and living in fidelity to that marriage. And that's what we're called to do. And we have to be very helpful. We should be close to those who are divorced and remarried and try to help them, but it won't help them at all to say, well, it's just fine that you're living as a husband and wife when you're not husband and wife. And so we have to try to help them to deal with that situation in a very understanding way, but in a way that assists them to draw on the grace which God gives to come out from that sinful situation.
In the last and final excerpt, Cardinal Raymond Burke answered the question that I asked when he was at Franciscan University on Tuesday. I had asked him whether the rest of the world is like the United States, where they give annulments to 98+% of the petitioners. At least that's what happens in half of the United States, according to the research that I found.
Next question.
I have a question for Your Eminence. You had talked about how in the United States there was kind of a waiving of a process before 1983, and it kind of led to what was perceived as a divorce mentality. Is that going on in the rest of the world? I've learned that in the United States, maybe where half the population of the Catholics live, the tribunals issue annulments to like 98% or more of the people. That's not in the whole United States, but that's a lot of the United States of the petitioners that get their petitions granted. Is the rest of the world the same way?
It could only be practiced in those areas which received also permission for these what were called special procedural norms. But it did have a certain influence in the Anglophone world, but it's not true for the other parts of the world. In fact, one of the difficulties which I was trying to address in the Apostolic Signature, have been trying to address, is there are a number of places in the world in which there are no tribunals, even though there are hundreds of cases of petitions for declaration of nullity of marriage. We're trying to urge bishops to establish tribunals. But the situation in the United States was particularly aggravated, and it behooves us to look at that now when these same ideas are being proposed.
Thank you.